Every day in the USA, people find themselves in court.
Good afternoon, sir. Are you James Charles Jude?
Yeah,
Mr. Jude, you're set for a preliminary examination this afternoon on a charge of home invasion, third degree, and malicious destruction of personal property over 200 but less than 1,000. It's alleged that on or about May 15, 2024, that you did break and enter into a home at Hiawatha Drive in Sherman Township. You also did damage to the window or other property at the house. You were arrested on this charge, you were arraigned, and the matter was set for a pre-exam conference. That was last Tuesday. Rhonda Ives was appointed to represent you, and she's here today. Also present is prosecuting attorney David Marvin. When we were here last Tuesday, we didn't get very far. As I understand it, you didn't wish to speak to Ms. Ives, and we didn't get very far, so we simply said we would schedule the matter for a preliminary examination. And that was set for today at 1 o'clock. A preliminary examination is a hearing where it must be established there's probable cause to believe a crime was committed and probable cause that you did it. I met with Mr. Marvin and your lawyer, Ms. Ives, in chambers, and he was trying to fashion some sort of a disposition in the interest of the public good, I'll say. And then both lawyers went back to talk to you in the lockup. And as I understand it, again today, Mr. Jude, you don't really wish to communicate with your lawyer, and so they weren't able to even get started as to anything. Mr. Marvin, what's your position here?
Your Honor, I believe that in talking with him, that he does not understand or appreciate the nature of the charges against him. And I don't think, from my opinion, that he could effectively assist in his own defense. I don't think it would be right to continue to pursue this without some kind of a competency. I don't say that very often. I usually advocate against it. But in this case, I do believe that it would be unfair.
Ms. Ives, what's your position?
Thank you, Your Honor. Well, I will clearly state that he is either unwilling or not able to assist in his defense. He has made some statements that to me are not rational, including the fact that the victim, Mr. Jude, who supposedly is either his adopted father or father, is not his father at all. So I have serious concerns about his competency and his ability to assist in his defense, specifically stating that he has not, when we try to talk about defenses, he doesn't want to offer any information. So it puts me in a quandary, Your Honor, and I would respectfully ask the court to refer the matter for a competency evaluation.
You agree, Mr. Marvin?
Yes.
All right, Mr. Jude, in order to defend you, there has to be some communication between you and your attorney. Ms. Ives is an experienced attorney. She's been practicing probably 20 years or more in Branch County here in St. Joe County. And she was unable to really establish any communication to discuss your case. So they're requesting that I ask to have you examined at the Center for Forensic Psychiatry for your competence.
No, I'm good on that.
Competence means that you
I
are,
shouldn't even be here.
what's that?
I shouldn't even be here.
Well,
You have nothing on me.
well, it isn't me. I didn't make the charge. Somebody else filed the charge. The police submitted a report to the prosecutor. The
Locked up
prosecutor.
for false claims.
All right, so that's your opinion. The whole thing is false and you don't really want to discuss it?
What's there to talk about? I shouldn't be here.
All right, we are here. So I can't wave my magic wand and make this go away. And both counsel are asking me to have you evaluated for competency.
I'm not answering no question.
All right, you don't have to. I don't know whether you're just unwilling to cooperate or unable to or both. But as a result of that, they can't even start to mount any defense. This is going to take months. You're going to be in custody pending this evaluation from the Center for Forensic Psychiatry. And Mr. Marvin indicates he usually tries to avoid it for the very reason that it takes so long to get it done. But your attitude is what it is. So I'm ordering that you shall undergo a
I
psychiatric
got the right to
evaluation.
remain silent, and that's what I'm doing,
Yeah, all right, then you do.
which I've never been read my rights. Not once.
All right, that's another misunderstanding. They only need to read you your rights if they want to ask you questions and use your statements against you. They don't have to read you your rights to
What do
arrest
you got
you,
against?
put you into custody.
Nothing.
All right, your answer is nothing, and I'm gonna
What do you got?
have you examined at the Center for Forensic Psychiatry. I'm not having any more success than anybody else did, so you can go to the court officer. Your bond will remain in the amount of $20,000 cash assured. Take me back so I can go to sleep. Apparently he's quite worried about it. Anyway, this may take a while. Good morning, sir. Can you hear me?
Yeah,
Are you James Juday?
yeah,
Would you rather stand or would you like to sit down?
I'm good.
All right, I'll leave you standing if you're all right with that. This is file number 24803FY. It's entitled People of the State of Michigan versus James Charles Juday. Mr. Juday is presently connected by a Zoom link from the jail. His lawyer, Rhonda Ives, is here with me at the courthouse, and Chief Assistant Prosecuting Attorney Joshua Robert is here. Mr. Juday, to recap, you got charged on May 15th with home invasion in the 3rd degree for a dwelling on Hiawatha Drive in Sherman Township. That's a felony punishable by up to 5 years imprisonment and a fine of up to $2,000. You also got charged with malicious destruction of personal property. You broke a window allegedly and spray painted some things on the house. That's a misdemeanor alleged to be over 200 but less than $1,000.
None of it's true,
Punishable
and you
by-
already know. So why am I here?
All right, here's why you're here. The matter was set for a preliminary examination and a pre-exam conference. Your attorney,
Yeah.
Rhonda Ives, was appointed to represent you, and you basically wouldn't talk to her.
There's nothing to say. I didn't do nothing.
All right, well, so we've referred the matter for a competency evaluation at the Center for Forensic Psychiatry. And we got a report from the Forensic Center on August 13th. It was date stamped August 16th. We're supposed to set a hearing in that matter within 5 days of the receipt of that report. Today's 4 days after we received it. So this is a hearing regarding your competency to proceed. You've been stuck in jail now for 97 days and the case has just been on hold.
It'd be nice to get a real lawyer too.
All right, well, we'll talk about that. Mr. Robert, on behalf of the state, are you willing to stipulate to the admissibility of the report?
Yes, Your Honor.
It is dated August 13th from Carissa Carlson, PhD, a consulting forensic examiner and licensed psychologist with the Center for Forensic Psychiatry. Ms. Ives, are you willing to stipulate to that report?
I would stipulate to it, but I object to the conclusion that's been made in the report based on the lack of review of an interview of the defendant.
All right.
You want me to plead guilty to something I didn't do? There's nothing to talk about.
Well, I don't necessarily want you to plead guilty. You're entitled to have a trial. And your lawyer is willing to represent you at a trial, but in order to do that, you have to talk to her. No one's trying to get you to plead guilty to anything. We're trying to just move forward with the case. And
I did talk to her.
All right, well, here's what the psychologist says. First of all, competency has to do with your state of mind right now, today, and the day of the trial. Criminal responsibility, sometimes referred to as insanity, has to do with your state of mind at the time of the offense. We're not concerned about that right now. We're just concerned about your state of mind now. I get the sense that you're an intelligent guy, but you've got some oppositional issues. The statute, the competency statute says, a defendant to a criminal charge shall be presumed to be competent to stand trial. He shall be determined incompetent to stand trial only if he is incapable, because of his mental condition, of understanding the nature and object of the proceedings against him, or assisting in his defense in a rational manner. The court shall determine the capacity of the defendant to assist in his defense by his ability to perform the task reasonably necessary for him to perform in the preparation of his defense. So the examiner didn't get very far with you. The video conference lasted about 5 minutes. Mr. Jude terminated the interview prior to being asked questions about his legal case and understanding of the proceedings. He demonstrated the ability to advocate for himself as evidenced by his understanding that he could terminate the interview. So here's the doctor's opinion, Mr. Jude. I was unable to thoroughly assess Mr. Jude's mental condition at the time of the present examination due to his declining to participate in the evaluation. Because of this, I was unable to directly ask him questions to assess his understanding of the nature and object of the proceedings against him, or to assess his ability to rationally assist in his defense. So they didn't get very far. Then she goes on to state, an opinion on competency is required regardless of the level of participation of Mr. Jude. The time of the evaluation is reported refusing all psychiatric medication.
I don't need medication.
All right, okay, that's, in my opinion, due to the limited, well, let me finish this last part, then I'll let you tell me what you want to tell me.
Go ahead and look.
Well, okay.
That's how I'm being treated in here.
All right. In my opinion, due to the limitation of not being able to directly evaluate Mr. Jude myself, and my understanding of the statute, one has to opine the presumption of competency. So their opinion is that you're competent. You're standing there with no shirt on. You're trying to show me how thin you are because of
how I'm being treated in here. Yeah.
All right.
Exactly what I'm doing.
All right. So you showed me that because of how skinny you are?
No, how I'm being treated in here. Poison gas, all that shit, you know about it.
So that isn't exactly a rousing endorsement for the doctor to find that you're competent. Mr. O'Bear, you have any anything to say about this?
In my review of the statute, the only other possible thing that I can see is for Ms. Ives to request an independent evaluation as one of the outcomes of this hearing. But it says that because of the presumption that the Center of Forensic Psychiatry or other facility officially certified by the Department of Mental Health will properly perform their functions, good cause justifying an independent competency examination should only arise in exceptional cases. So I guess that's one possible option. I don't know if any evaluation by any other person would result in a different outcome based on his unwillingness to participate.
All right, Ms. Ives, what's your position?
Well, Your Honor, I have some serious concerns if they're not able to fully interview the defendant. I don't believe that an accurate determination can be made, and based on statements that he made to me prior to, that caused my request for the competency evaluation causes me some great concern. I'm also concerned the fact that there were reports from the jail that the jail was supposed to send, and they if I look on page 2, those records were supposed to be sent on August 8th promptly, and then as of the date of the report on August 13th, those records were not received. I'm not sure what is in those records, and I'm not sure, but I think that they would be very appropriate to review, as well as have a full evaluation with the defendant. I mean, if that means we have to do an independent valuation, I guess I would ask the court to allow me to find the resources to do an independent valuation, or refer them back to Miss Dr. Carlson so that she could try to re-interview the defendant, and hopefully he'll just cooperate with that interview so we can make steps and proceed forward.
Well, Mr. Jude, what was scheduled was a preliminary examination and a pre-exam conference. This is a felony charge. One is a felony, one is a misdemeanor. You've got a $20,000 bond, and everything just gets stopped in a timeout when there's a competency hearing.
Got any proof on anything? No.
So we weren't able to do the pre-exam conference, and we weren't able to do the preliminary examination. So I ordered this evaluation, and they did it, but it didn't go very well because you weren't very cooperative. So go ahead, sir. What do you want to tell me?
I've been telling you everything. There's nothing what do you want to know?
Well, do you want to go forward with your case? Do you want to have a trial? You have a right to have a trial where the prosecution has to prove the case beyond a reasonable doubt. We can't move forward in the posture we're in right now.
Well, yeah,
you
I'm
don't
not trying
have
to stay in here for no reason, man. I'm already in here for no reason over 90 days. Did you look at
97
me?
days.
You see how skinny I am and shit?
Yes.
Yeah, you know.
Let me ask this. If I were to release you today, where would you go?
I don't know. I'd figure it out.
Well, I'd rather figure it out first.
Well, I gotta be able to go get my shit.
Yeah. Well, are you willing to talk with your attorney so she can proceed to prepare your case for trial?
I don't care, man. If it gets me out of here. You see me, I'm starving, man.
Well, I see it. All right.
Getting poisoned every day. Gas, yeah.
Say that again.
Getting poisoned and gassed every day too. I know you don't care, but
What's that from?
ask them.
Did he say he was poisoned with gas? Mr. Jude,
Yes.
is that what you said?
He said he is poison gassed every day. The jail staff says you're on a quasi hunger strike and that you refuse to eat.
I've been eating.
All right, well, do that.
Your Honor, I'm confused. Is he making a statement that, what does that mean, poisoned gas?
Well, you heard the same thing I did. He contends he's being poisoned by the jail staff with poison gas. And he said, ask them.
You gonna let me out today or what? You just said something about it.
No, I just asked what you would do if you had somewhere to go. No, I'm not inclined to let you out without cooperating with your attorney. I can't even get to
No,
the first stage of the proceedings. You've been in jail for 97 days. If I order an independent psychiatric evaluation, it's probably going to take another 90 days. I don't believe that you're being poisoned by poison gas at the jail. It doesn't matter what I believe if you believe it. So what would happen if I find you to be competent? I would set the matter for a pre-exam conference where your lawyer would come and meet with you and discuss what to do with the case. It could be reduced with some sort of a plea agreement, or you could have a trial. Nothing prohibits you from having a trial where you have to be proven guilty beyond a reasonable doubt. But we can't even get to that point. This business about your belief you're being poisoned is new to
can you bond
this.
me out? I've already tried. They won't let me.
Well, your
Okay.
bond is $20,000 cash or surety.
Yeah. I've already tried.
Well, there were
the whole-
also allegations that you violated a personal protection order. That's why the bond is so high. You kept going back to a place you were ordered to stay away from.
Well, I gotta go back to where my stuff is.
Well, we'll get to that point. At this point, I'm inclined to grant defendant's motion for an independent psychiatric evaluation.
And you do what you gotta do.
All right, thank you, Mr. Jude.
I'm talking to somebody.
What I'd like you to do is cooperate with the next doctor and see if we can move forward here. Because
I'll talk to the doctor. There's nothing to talk about, but.
all right, I asked
need
you to
to-
cooperate. Maybe we get.
I mean, come on.
All right, well, I've seen enough of that. So, all right, Mr. Jude, have extra French fries or something. I'll be seeing you at our next hearing.
I wish I was eating.
Let me look at the order. See what it says.
But he's on his own hunger strike, I think.
Well, that's what the jail staff says. He says he's eating. This order doesn't have anything in here. All right, I will do an addendum to this saying that I grant. Josh, you were looking at the statute. What section
So
is?
it's Michigan Court Rule 6125D, independent examination on a showing of good cause by either party, the court may order an independent examination of the defendant relating to the issue of competence to stand trial.
I did it once when I was prosecutor. Although it was upside down, the forensic center found the defendant to be competent. I was prosecutor. I didn't think she was competent. So I got an independent evaluation from an excellent doctor, Dr. Charles Clark. And he found her to be, actually it was that's a long story, but it was a terrible homicide case. All right, the trick is you got to find somebody, an independent doctor, to do the evaluation. I don't know if MIDC has some assistance in that. And MIDC may need to pay for the evaluation. But I can't tell. He was doing pretty good until we got into poison gas. And as the jail indicated, he he's on his own sort of hunger strike. He didn't look any skinnier than Iggy Pop, but I don't know what he looked like before. So I will do an order for independent evaluation.
Okay.
And in the meantime, the bond will remain where it is. All right, thank you.
Thank you.
That's a tough case here. I don't really want to just leave him there, but I don't want to just let him out either. He has nowhere to go. All right, thank you both.
Thank you. Thanks, Josh.